this provision basically stipulates everyone has the right to have the environment protected through reasonable legislative measures. And the EIA regulations and the NEMA, the Act, are those legislative measures. And I will talk more about these two pieces of legislation later on. So this is an overview of environmental law in South Africa. So just remember that this is not an exhaustive list of all the environmental laws in South Africa. What this diagram shows is the National Environmental Management Act, that's NEMA, which is the framework environmental legislation. And you'll get an idea of what I mean by that later on. And then you have all those various specific environmental management acts, which we call the SEMAs, S-E-M-As. So we have the NEMA, and then we have the SEMAs. So a bit about NEMA, which is the National Environmental Management Act. So I explained that it's the framework environmental legislation in South Africa. And what we mean by this, and it's stipulated in the Act, is that that Act guides the interpretation, administration, and implementation of laws concerned with the protection or management of the environment. So that's quite broad. So what it means is that any other act or provision in any other act that concerns the protection or management of the environment, those provisions must be interpreted by using NEMA as the framework legislation. So all the principles that are contained in NEMA will have to apply to these various other environmental legislation. Now, Chapter 5 of NEMA talks about integrated environmental management. And that specifically Section 24 now gives effect to the requirements for EIAs. And EIA is an environmental management instrument. So, but the strange thing is it's not specifically listed under the definition of environmental management instruments under NEMA, but it is an environmental management instrument. Otherwise, we won't be using it. So let's talk about the EIAs. The EIA process is legislated by the EIA Regulations. Right at the top there, Environmental Impact Assessment Regulations 2014. And the EIA process, can you see there? Sorry, I have to admit someone waiting in the lobby. Sorry about that. The EIA process is triggered by activities which may fall under the various pieces of legislation. So let's look at them. Right. So first you have the listing notices, which list the various activities requiring EIA. Hopefully you've went through, if you're new to this, you went through that listing, at least one, to get a feel of what a listing notice looks like. Right, so there's a listing notice 1, listing notice 2, listing notice 3. Then you have certain areas in the country which may have what we call environmental management framework in place. And these frameworks, there may be certain activities in certain areas which will be listed activities under these frameworks, which may require that an EIA be done. So that's another trigger, potential trigger for doing an EIA. 8 of NEMA. Section 28 talks about the duty of care and remediation of environmental damage. Now, this provision under NEMA empowers the relevant authority or the competent authority to direct a person to cease or stop a damage-causing activity, and among other things, direct them to carry out an environmental impact assessment. Well, it doesn't say specifically carry out an EIA, but it says that you must assess the impacts of that activity. Then there are other triggers for EIAs in the form of further listed activities. And these you can find under the Waste Act, the NEM Waste Act, and even the Air Quality Act, which spells out specific activities which require a permit and an EIA to be done. So the EIA regulations, as we know it, is made up of three well, not three, it's four government notices, right? And you can have a look at those in your course material. And I'm not going to refer to them by government notice numbers, but essentially, the first one is if you want to call it the real regulations. And the environmental impacts assessment regulations spell out all the procedures, the timeframes, the rules, report requirements. It basically governs the entire process, how the process should be run. So that's the main sort of EIA regulations. And then tied to those procedural regulations, then we have the three listing notices, listing notice 1, 2, and 3. These contain a whole list of development activities, and we'll talk about these in more detail later on. All right. So majority of you fall under this category. You're either a candidate or an environmental assessment practitioner. So what is an environmental assessment practitioner? Now, in terms of the Act or the regulations, it is an individual responsible for the planning, the management, the coordination or review of environmental impact assessments, strategic environmental assessments, environmental management programs, or any other appropriate environmental instruments introduced through regulation. So that's quite a broad category, which most of you guys fit into. Right, so essentially environmental consultants, I think most of you are, who conduct EIAs, and then government officials, the guys who actually review your basic assessment reports, and the guys who actually read it, review it, and some of them even draft your environmental authorization. So those guys are also referred to as environmental assessment practitioners, or they are environmental assessment practitioners. So the general requirements are in the regulations, and they are as follows. An EAP, an environmental assessment practitioner, must be independent. And by that, we mean not have any vested interest in the outcome of an application. I'll explain that further. Second, must have expertise in EIAs and knowledge of the Act and regulation. So this talks to the experience and qualifications, etc. Third requirement is to ensure compliance with the regulations. Next, to perform work in an objective manner. And most importantly, disclose all material information that may have the potential of influencing the decision of a competent authority and influencing the objectivity of EIA reports. Now, Regulation 13, subsection 1A requires an EAP to be independent. In other words, not have any vested interests in the outcome of an application. Now, someone, for example, is an EAP at Eskom, who submits an application on behalf of Eskom for an environmental authorization. and he or she does so as an EAP on behalf of Eskom. So that person or that EAP would not be regarded as independent because they work for that entity who needs to do the EIA and get the environmental authorization. And the EAP obviously works for that entity. So in these situations, well, look, the regulations are not that strict as far as I'm concerned. And so there is a provision under the regulations which say that in this particular situation, like the example I've given you of Eskom, is that that another EAP, an external independent EAP, must be appointed to conduct an external review of all the work done by the EAP that actually works for Eskom. So I work for Eskom. I did drafted all the basic actually this must be done before public participation. So all the work that I do as an internal EAP would have to be reviewed. We'll have to appoint someone from the outside as an EAP who will do an external review of my work as the non-independent EAP. And then the legal requirements. So back in the days, anybody could, moonlight as a environmental practitioner. But now we have compulsory registration. So no one can do those activities that EAPs need to do without being registered in terms of the Registration Authority Regulations 2016. Accountability of EAPs is one of the most important, crucial requirements. It's an ethical requirement. But the regulations also have punitive measures in place. EAPs that obviously decide to stray from the requirement of accountability. So a person can be held guilty of an offense if they provide incorrect or misleading information or omits crucial information. And then it's also an offense to fail to comply with 13 subsection 1F. Sorry, that's regulation 13, subregulation 1F, which relates to the disclosure of material information. And I'm sure most of you are familiar with this. So this was the first and probably the only, which is a bit worrying, the only case where a practitioner was criminally charged. And that related to a matter where there was a wetland on the property, but it wasn't disclosed in the EIA. And this guy and his firm were found guilty of providing incorrect and misleading information. So that charge was brought in terms of the EIA regulations. There was an additional charge of fraud, but obviously that I don't think that was a competent charge to bring against this guy. But so that obviously has negative impacts on you as an EAP and your client as well. If you end up in a situation like Mr. Frelink and Impofo Environmental